Thanks, Steve. I have some notes I have to share with you because I can't possibly remember all this information about our distinguished panel today. This is really an extraordinary gathering, if you will. So in no particular order, just the way they came up in my notes, let me please introduce our panel. From New York, Christine Pepe is the Director of Legal Affairs at ASCAP, the American Society of Composers, Authors, and Publishers. And ASCAP collects performance royalties for publishers and songwriters, one of 3 performing rights organizations we have in the United States. Prior to joining ASCAP, Christine practiced intellectual property law, most recently with New York Law Office of McDermott, Will, and Emery, where she represented a diverse group of clients on a variety of matters, including not only traditional copyright infringement, including fair use issues, but also violations of the Digital Millennium Copyright Act. Today she represents ASCAP in licensing and litigation matters relating to traditional media, such as local radio and broadcast network television, and to evolving new media, such as internet portals, social networking sites, and wireless platforms. Thanks for being with us today. Okay. From Chicago, I was looking at the map earlier, and I said we have New York represented, Los Angeles, Chicago, Texas, and Nashville. So from Chicago, Steve came down on the train this morning, Mr. Steve Albini, engineer, singer, songwriter, guitarist, and music journalist. He was a member of Big Black, Rape Man, and is currently a member of Shellac. He's founder and owner and engineer of Electrical Audio, a recording studio complex located in Chicago. Montana native, he's made over 1,000 records by over 1,000 bands. I actually saw on one website up to 2,000 albums. Lost count after the first 1,000?
Yeah, I have no idea.
Okay.
2,000 is a nice round number.
Okay. Including Pixies, Nirvana, PJ Harvey, Bush, Page and Plant, and the Stooges, amongst another 1,500 or 2,000. Okay. So welcome, Steve. We had a conversation in trying to arrange how to get him down here, and he said at one point, given kind of limited options, because I think you had a session last night,
Yeah.
Okay, I'll take the early morning train. So, thank you.
Cry me a rivers. My life is hard.
Rand Bishop from Nashville is a Grammy-nominated, BMI award-winning million-play songwriter with over 200 cuts to his credit by such artists as Tim McGraw, Beach Boys, Heart, Cheap Trick, Indigo Girls, and Vanilla Fudge. That takes me back. Rand's song My List, recorded by Toby Keith and co-written by Tim James, spent 5 weeks at #1 on the Billboard Country Singles Chart in 2002 and became country radio's most played song of the year. In his nearly 40-year career, Rand has filled just about every role in the creative end of the music business, including recording artists on Elektra, A&M, MCA, and Epic, session vocalist and producer, and A&R exec and publisher. Rand has a brand new book out called Making Stuff Up, which I'll let him talk to you about a little bit. He gave a presentation this morning over in the music school, and by the way, there's another one tomorrow at 10 a.m. to noon in room 117 in Altgeld, where Rand will talk more about songwriting. So thanks, Rand, for being here. And just a note, Rand, I think we were talking the other night, I think it was 1991 when we met through mutual friends in Los Angeles, and I had the distinct pleasure of getting to work with him on a couple of songs way back. Patrick Burkhart researches and writes on the music industry, digital distribution, and technology policies. He's written a new book called Music and Cyber Liberties on hacking, culture jamming, and radical media that will be out in 2009. So do we know when this year?
November.
Okay. He also co-wrote Digital Music Wars, ownership and control of the Celestial Jukebox with Tom McCourt, and he's an assistant professor of communications at Texas A&M. Thanks, Patrick. And from Los Angeles, Chris Castle is managing partner of Christian L. Castle Attorneys with offices in LA and San Francisco. The firm represents artists, producers, songwriters, record labels, music publishers, film studios, and technology companies. He's also a managing member of the Digital Media Policy Group, a private consulting company. And Chris serves on the boards of several academic and industry organizations and lectures at business schools and law schools. He has held senior business affair positions in the music industry, and he is a fellow of the World Technology Network and is a contributing editor to Entertainment Law and Finance. He has spoken on public policy matters at the UK Parliament, congressional seminars at the US Congress, and at conferences of the Organization for Economic Opportunity and Development. Thank you for joining us, Chris. Where to start? We've been talking about this panel for some time, and so there have been strings of emails going back and forth. What do we want to talk about? And in the broadest topic, we said, well, let's talk about fair use. How does it impact us? What is it? Ask 10 different people, and you'll probably get 10 different answers. And Chris framed this really well, and I'd just like to, if it's okay with Chris, use this quote. And it's kind of the inquiry for our panel today. Okay, we'll give a number of different examples that we can apply to this inquiry. But Chris asks, should copyright encourage an individualist regime where authors' rights are primary, or a collectivist regime where authors' rights are secondary? Do fair use, Creative Commons, hybrid business models where value is derived from but not shared with content owners, and the commoditization strategy of some online companies all point to a collectivist regime as the future of copyright? That's a question. Okay. So I wanted to start this with actually an example that has received a bit of press and by some is considered rather trivial, and by others, extremely controversial. So let me just play this video clip, and then I'll turn it back to Chris.
Never follow an animal act.
Animal or children.
Okay, do we have audio? That's it, all of 29 seconds. Chris, do you want to start off with that? As far as what's the issue here? What happened?
Well, the issue is, I guess that was a Prince track. I couldn't really hear it myself, but apparently.
That's part of the issue, huh?
I don't know if that's the issue or not. It's the issue for me. Not really. But the issue is that somebody used a Prince track for their home video, and then they posted the video on YouTube. And then Prince, I think, and Universal, although I'm not quite sure, I guess it must have been Universal Publishing, sued for an infringing use of the work, and the mom, I guess it was, defended the case. How the mom, was able to defend the case, I'm not quite sure, but it reached a decision in the federal district court, in San Jose, California, before Judge Jeremy Fogel, who's also a professor at the Stanford Law School, in which Judge Fogel decided that that was a quote-unquote fair use of the Prince song and recording, and that there was no infringement. So let me sort of point out a couple of things here. First of all, it's a good idea at the outset of this panel to remember that fair use, as we use it in this country, is a defense to copyright infringement. It's what they call in the law an affirmative defense, meaning that if you're sued as an infringer, you say, I may be an infringer, but I have a defense or a justification for what I did, and that defense in this case is fair use. And then there are criteria for what is a fair use and what is not a fair use, and then that gets litigated, and it's a fact question as to whether or not something is in fact a fair use. So when you talk about fair use, something is a fair use when either people decide not to sue each other about it, or there's a final non-appealable judgment. There's not like a book you can go look up and say, 8 seconds is fair use, or if you do thus and such, it's fair use, or anything like that. It's a legal conclusion. And so what Judge Fogel ruled was that before a copyright owner sends a takedown notice under what's commonly called the Digital Millennium Copyright Act, although that's a bit of a misnomer because it's really just the Copyright Act, that copyright owner has to determine whether or not the use that they're sending the notice for is a quote-unquote fair use. Now, given what I just said about fair use being a legal conclusion, it's kind of an odd decision, right? Because it's a judge saying that a copyright owner has to decide whether something is or is not a fair use, which is not something that a copyright owner can decide. So this is one of those situations where lawyers often say bad cases make bad law, right? This is a case that should never have been brought. This is an idiotic case. No, the plaintiffs were crazy to bring this case. So guess what? They get a crazy decision. The other thing you should realize is that although YouTube was not in front of the court, what Judge Fogel did was effectively codify, if you will, the notice and takedown policy of YouTube. Because what YouTube does is they send at least the close cases to something called the Chilling Effects Clearinghouse, which is an organization run by the Electronic Frontier Foundation, the Stanford Law School, a legal clinic at the Stanford Law School, a legal clinic at the Berkman Center at Harvard, and a couple other people I'm forgetting. But it's basically a group that takes in these videos and decides whether they think there's a fair use. So what Judge Fogel is basically saying to copyright owners is get a legal opinion as to whether something like that is or is not a fair use before you send your notice. So what the DMCA would then require, according to Judge Fogel, is that not only do copyright owners have to monitor the internet 24 hours a day, 7 days a week, to determine whether any of their content is being infringed upon, because the way the DMCA gets interpreted is that you can do it as long as you get away with it, which is not really what it says, but that's what a lot of people think. And in addition to having to monitor the internet 24 hours a day, 7 days a week, if you ever do decide to send a notice, you have to get what's effectively a legal opinion before you send the notice as to whether something is a fair use, which is a decision that can only be determined once you've had a final non-appealable judgment. So you can see that this is sort of an odd result, which, some cynical people might say was not surprising coming from a judge who, when he's not being a judge, is a professor at the Stanford Law School, which is essentially owned by Google, right? But that would be sort of an uncharitable thing to say, so I'm not going to say it. So that's essentially the Lens case. I mean, it was a stupid case. It should never have been brought. And, you know, as someone who used to work at a record company, I will tell you that when that was many years ago, but when I was there, one of the things that used to drive us crazy is we'd get these requests for, like, wedding videos, right, using our tracks in wedding videos. And the groom usually would be calling, wanting to get a song cleared. And guess which song they wanted to get cleared? It was the song for the first dance of the groom and the bride, right? Kind of an important part of the wedding video. And so the videographer would not give them copies of the wedding video until they got rights cleared, right? So they would be calling us. Now, I will tell you that we have a lot of things to do at a record company, right? And I'm sympathetic, but these things used to drive us crazy because, as you can imagine, the groom has got a little pressure on him, you know, to get this thing cleared. So they would scream at my assistant. So I invented this fictional character, I have to say, called the licensing manager. And we had an outgoing message that wouldn't have any, had no voicemail that could be left for it, and said, if you want to get your thing cleared, get a pencil because you're going to need to write this down, right? And we had them go get artist consent, publishing, blah, 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 blah. So we came last, right? Because we would have to charge. I mean, there's a minimum fee that you have to charge in these situations, or else you kind of go under, right? If or not under, but you know, it's a drain on resources. I mean, like $1,500, you know, not a lot of money, relatively speaking, right? I mean, for us, not a lot of money. For them, that you say $1,500, they think you're, you know, a charlatan, right? So that was the end of the wedding video requests, which was fine with me. You know, I don't really, because frankly, I don't really care if they use Sting for a wedding video. You know, it's not worth my time to try to figure it out. That's what should have happened here, right? What should have happened here is somebody should have just looked the other way. It doesn't mean you give up your rights. It doesn't mean, yeah, you could construct a lawsuit and this sort of insane set of facts, but why bother? You know, it's not worth it. And just as an aside, one day my assistant came in and said, I have a package here addressed to the licensing manager. I'm like, is it ticking, you know? And it turned out that somebody had actually gone and done all this, and there was this package of stuff. And I called this guy up. I said, hi, you don't know me, but I'm the licensing manager at A&M Records, you know? And I got your package. And he said, really? You know, are we going to get the license? I said, yeah, you got it for free. I'll just give it to you because you did what I asked you to do, you know? Now, some people will say that's high-handed and arrogant record company, you know, activity, but the fact of the matter is that guy was very happy, as so was his bride. So it was the least I could do for his family.
Thanks, Chris. That kind of nicely segues into, you know, taking a look at the law and perhaps a great deal of uncertainty surrounding some of these uses. I'd like to open up a question to Patrick and Steve, and I'm not sure who should tackle this one first, so I just want to kind of put it out there. But it's based on something that you said during lunch today, Stephen. I don't want to put words in your mouth, so correct me if I didn't write it down quickly enough. So you said something to the effect that you were looking forward to the collapse of the current intellectual property scheme.
Yeah.
Okay. And
because I think it's ridiculous that anyone should have to get permission to make a wedding video. It's just, that seems like normal human behavior, and I think criminalizing or making normal human behavior subject to like a convoluted legal process or even a checklist and a mailing in of a package, I think is preposterous.
so this is not a matter of, you know, changing the law, relaxing the law, fortifying the law, but rather just taking a...
Well, I think it's obvious that the use of music, we're basically talking about music here. I mean, it does apply to other things, but we're basically talking about music. It's obvious that the use of music in people's lives has changed over time. Every time it's changed substantially, there's been a paradigm shift in the music industry where the existing model of the music industry that controlled the distribution of music had to change radically. And in changing, the old guard, that is the people whose careers and lives have depended on the older model, were resistant to change and tried very, very hard to maintain status quo, or to maintain some semblance of status quo, so that they could maintain similar money transfers, or similar control over the content and the money that it was exchanged for the transfers. And eventually the dam broke, and the paradigm always did change, and it adapted. It's normally adapting to new technology. Like, for example, when court musicians were the only way that you could hear music, then the publication of sheet music allowed people to hear music in their homes. Then, things like player pianos, local musical groups. There was the publication of music that allowed people to play music in their homes. The radio, phonograph records, home tape duplication, cassette tapes, things like all of these different changes in the dissemination of music have caused sort of structural changes in the music industry that was by and large resistant to those technological advances. And here we're seeing an example where music is now sort of become part of the environment for a lot of people. They no longer sit in a chair and play a single record and stare at the hi-fi while they're doing it. They have their laptop playing iTunes, or they'll have an iPod with them, or they'll have kitchen radio type scenario playing music basically all hours of the day. And here we saw a video of a little kid dancing to music that was part of his environment. And again, perfectly normal behavior. And the parents documented that perfectly normal behavior. And someone who was stuck on a previously existing notion of music, where if you wanted to play music in synchronization with a film, then you had to get a synchronization right for it. And here we're seeing music clearly used as the soundtrack to a film, But I mean, obviously the video that we're looking at did not fit the model of a film with a score. It was just a snippet of ordinary life that happened to be captured. And I'm in all facets of life. I favor treating normal life normally rather than formalizing it in any way.
Patrick, you've written on such uses. Could you follow up on that with Steve?
I endorse Steve's idea about this particular video being more like a documentary of everyday life, And I know legal scholars have spent a lot of time working with documentary filmmakers, for example, and kind of clearing an area for what is fair use. And I would just kind of append what Chris said about fair use. It's more than a legal defense at trial, right? It's an exemption from copyright that artists and filmmakers and ordinary people who are using media non-commercially as well as commercially rely on in order to communicate their ideas. And just because these ideas happen to reside in a digital domain shouldn't mean that as creators we have any less right to represent our documentary lives in a documentary way. So in that sense, I do see some risks to this kind of video even becoming a debate, because it really shows how far afield we've traveled in a very short time from kind of an unquestioning attitude about fair use to a much more juridical and also punitive system. Remember, some of these platforms that we're talking about, YouTube in particular, they haven't even been around for 5 years yet, right? And we're talking already about copy crimes that could put a mom documenting her toddler, into a very difficult legal situation. So I think a lot's changed quickly, and there's some risks attached.
Rand, being a songwriter, and let's open it up beyond this case, but as far as unauthorized use, or fair or otherwise, of your material, in the context of something like YouTube, if it were a longer excerpt, you had given an example last night, had you licensed a song for a film, and snippets or large portions of that film that your song is in show up on something like YouTube without your permission. How would you address that as far as from the songwriter and a publisher standpoint?
Well, I think the key word there is context. we do have the opportunity to negotiate a synchronization license for anything that is put to picture if it happens to be a commercial product. And that, of course, that sync license represents not only the copyright itself, but it also represents the performance. They're separate and different licenses, but each performance, of course, requires that. So it becomes a pretty complex situation, I think, for somebody like Prince and or Universal to sue anybody for that particular video is beyond ridiculous. I certainly would not participate in something like that myself. But by the same token, if a work that I had licensed for a particular use was being used for the purpose of some commercial use, then obviously I would object to it. The question, I think, and I think Christine mentioned this last night, YouTube sells advertising. Part of what they do is they give you and I the opportunity to put our videos up there for free, to store that information, and attract people to the site through our work or our home videos or whatever we happen to post. But they're selling advertising based on that visual content. So it becomes a pretty interesting question when music and or any other copyrighted material is being attached to something that is attracting people to the site. And if I were to put, for instance, something of my own on YouTube, then obviously I would have given them permission to utilize that material. But if it happened to be coming, as you say, from another source, in other words, somebody happened to tape a television show or something that I had content on, then it would be an issue that maybe we might consider looking at from a different point of view.
Okay, Christine, based on what ASCAP does, and again, applying that to this context, your comments.
Well, I think this is the example that we saw is probably the most innocuous example, and
That wasn't an accident as far as why I chose that.
there are more egregious examples of infringement on YouTube, and just as some examples are the fact that if you miss a TV show, where do you go to see it? You go to YouTube. You can watch 24. I actually missed 3 episodes of 24. I can go to YouTube and watch it. And YouTube, and that's unauthorized. In other words, the content holder has not permitted YouTube to post that. It's somebody who maybe got it through their TiVo and uploaded it.
But that's also great.
No, it's not, because
But if I miss the episodes, I get to watch them. Why
yeah,
is
but
that bad?
the content holders, the copyright owners, aren't getting compensated for that.
Sure they are. They got compensated when it was broadcast, and there was advertising during that episode, which is also on YouTube, which I'm also
But
going to
they
be
also have
subject.
legitimate outlets where you can see it, like, NBC.com and
Well,
things
they're
like
not
that.
as good as YouTube, apparently, because they can't compete with YouTube.
I'm sorry, I think I'd just like to not be interrupted
Okay,
for
all
5
right.
minutes. Also, music videos that have legitimate outlets where the artists aren't getting paid when their music videos are being performed on YouTube. Also, you can go to YouTube and stream music. And there's actually no video. This is kind of a new phenomenon where there's just a stagnant video and they're playing songs. So you can actually just stream songs and create playlists on YouTube. And while that's great, the songwriters have a right a performance right in the musical work. It's the underlying work, it's the lyrics, and it's the music. They have a right to be paid for that and earn a living from writing songs. And that's what ASCAP's goal is, to protect their rights so that they can earn a living from being a songwriter. That's the underlying basis of IP laws, is to encourage people, encourage creativity by protecting it. It's supposed to provide an incentive for creativity. So if you completely kill that by letting people rip off your works, you have to wonder what's going to happen to the creators. And no, people don't engage in art to make money, but you should be able to make a living from being a songwriter. And I would just like to ask Rand one question. Say this video wasn't this cute little baby dancing in the kitchen, but something else that maybe you found slightly offensive and you didn't like. Would the situation be different? It wouldn't be commercial, although I disagree with that because YouTube is making money. But wouldn't you want to intervene? Wouldn't you have a problem with them using that if you didn't like it, if it was offensive, or somehow it associated your work with something that you just, that really took value from your work? See, another thing is that when you create something, you should have the right to control it, because it can lose value if you lose control over that. It's just out in the world, and anyone can use it any way they want, and you no longer have control over your work. It decreases the value of it. And Prince is especially very sensitive about people using his work, but how would you react
That's
to that?
a really interesting question. I think it's another question besides the fair use question. Of course, I'm not a legal I'm not a lawyer like you guys. So, but a friend of mine, Cynthia Weil, told me a story about she and her husband Barry Mann and Phil Spector wrote a song called "You've Lost That Lovin' Feelin'." I'm sure you have all heard it because it's the most broadcast song in the history of radio. There was a condom company in the UK that asked for a license to put that song in a commercial, television commercial, and they wanted to pay quite a bit of money for it. You've lost that lovin' feelin', a condom commercial. Well, this was literally $1 million in cash in the pocket of each of the songwriters. Now, Barry Mann and Cynthia Weil certainly are not hurting for money. They've written 35 top 5 songs, some of the greatest songs of all time. They turned it down. But they didn't turn it down because there wasn't enough money. They turned it down because that exposure to the song would devalue the copyright. That was their feeling, that it would have destroyed the value of that particular song. So the question is a really good question, because if a song is inadvertently or out of the copyright owner's hands attached to something that they feel is offensive or in any way ethically challenging, then obviously that copyright owner should have the opportunity to stop that use. And I certainly would do that. I mean, certainly recently we've seen political campaigns using songs by artists that didn't adhere to the beliefs of the politicians, and they have asked, the politicians to desist from using those particular songs. That's, of course, an entirely different issue, but I do feel that copyright owners should have the right to do that.
Hey, can I just add one thing to that? So, a number of years ago, A&M had a record called "Everything I Do It For You," which was performed by Bryan Adams. It was written by Bryan and Mutt Lange. And this is life and business affairs. I got a call one day saying, David Duke, who some of you may remember was a racist politician in well, he's no longer a politician as far as I know. He may still be a racist, but he's not a politician, who was running for something, I don't know what, in Louisiana. And he was playing it, now this is sort of clever, he was playing it live at his fundraisers, right? And so, because we don't have a public performance right in the sound recording in the United States, we couldn't stop him. Because the Hall had an ASCAP BMI license, the publisher couldn't stop him. So who could stop him? Bryan Adams. And the way Bryan Adams could stop him was that Bryan Adams said, this is creating an implied endorsement of you by me for you to play this thing at your fundraisers. You will stop, or the hounds of hell will descend upon your head, even in Louisiana, right? So that's what we did, and it stopped, right? Now, the reason we were able to do that is because of the IP laws that protect Bryan Adams' persona, right? It was a bit of a stretch, actually, in Louisiana because you don't have these are state law matters very often, and you don't quite have the same rights of privacy and publicity and so on in some states as you do in other states. In California, you have a lot of protection for right of publicity, for example. But, we made a good saber-rattling move, and the guy stopped. But the reason he stopped is because he didn't want to find out the hard way that we were right, or that Brian was right. So this is why these rights are important. Like, I don't question Prince's ability to bring that lawsuit. I question his judgment, but I don't question his ability to bring it, and I wouldn't want him not to be able to bring it for these reasons. Because one of these days, it's not going to be a dancing baby. One of these days, it's going to be David Duke.
Dancing hooker.
And it's happened to me. Or something like that. And this comes up all the time in sampling. We just went through this with the Rolling Stones and Lil Wayne, right? This has come up with, you get some of the most bizarre sampling requests sometimes, for particularly for women artists who are not going to want to be associated with some of the language that's in the songs, right? So it's important to have the ability to say no, right? Because otherwise you find yourself dragged into these situations that you really don't want to be in, and you don't really have any other way to get out of.
Just real quick, before we go on any further, I think we should make a distinction between the musical work and the sound recording, just so that everybody understands that when there's a song, a recorded song, there's two different rights that are there. There's the rights in the musical work, which is the lyrics, the composition, and then the sound recording, which when a song is written through a music publisher and the record labels, there is a sound recording of that work. And a lot of times, the songwriter who has the rights in the musical work is not the same as a performing artist. Examples: Christina Aguilera, Britney Spears, I'm trying to think of some other, but any of the boy bands from 1980. So there's a lot of examples. So it's important to remember that there's two different rights, and in the musical work, that's the right that ASCAP represents. It's the performance right. So, when you think, oh, they're getting paid a lot of money through concerts, T-shirts, et cetera, that doesn't legitimize piracy because the songwriters are getting hurt.
I disagree that the songwriters are getting hurt. I'm speaking as a songwriter. And I can give you quite a few examples, but my band is on an independent label, Touch and Go Records. We have reasonably good international distribution, but in a lot of smaller markets, it's very difficult to get physical records, especially in places that have marginally functioning economies to start with: Asia, Eastern Europe, Africa, for example. My band last year was able to do a successful tour of Eastern Europe, including, Macedonia, Poland, the Czech Republic,
Bulgaria?
Bulgaria. We did Serbia. We didn't play in Albania. Anyway, and all of these places that have, that have either the remnants of what's left of a war economy or very little infrastructure for normal regular commerce, and our band was largely known in those places through the internet, through music available on the internet, or through what some people would call illegal copies of our music, which changed hands in a kind of a samizdat fashion, where one guy would have a copy of the record, he'd make cassettes for his friends, they'd listen to it, whatever. And my band had a successful tour of Eastern Europe, and all of these places where we probably, in the 10 years that the band's been going, or 15 years the band's been going, we've maybe sold a few thousand records total, but we sold something like 30,000 concert tickets on this tour. And that's a multiple of the number of people that we could have expected to come if those people were only allowed to hear our music through corporate sanctioned official means. We were able to develop a fan base, a worldwide fan base, at no cost to ourselves, zero cost to us to disseminate our music. We didn't have to pay radio pluggers. We didn't have to have a promotions person. We didn't have to have management presence. We didn't have to have a record label. We didn't even have to have physical distribution of our records. And our music was able to travel around the world to meet people who enjoyed it. And we created relationships with those fans. We now have a fan base in a part of the world that was literally untouched by the so-called legitimate music industry. And that's true for a lot of underground bands and a lot of bands who didn't have immediate mass commercial appeal. Granted, for immediate mass commercial appeal artists, for your Christina Aguileras and people of that nature, then the mainstream music business and the mainstream music distribution model is going to be the dominant one, and however that industry goes is how those people are going to carry on. But there is a large portion of the music scene that does not operate on those corporate terms. It's a parallel industry, and the more encumbrances are put on things like YouTube, for example, that prevent them from doing things that actually work to benefit the smaller, less corporate insinuated parts of the music scene, the more that end of the music scene is being actually burdened. We actually then are forced to go through official channels, forced to pay payola, forced to participate in,
Payola is illegal.
It is illegal, you're right. My point being that the mainstream conventional music industry serves its model, and it has been the dominant model. And an awful lot of the intellectual property law is concerned with carrying on monetizing that control structure. But my point is that the breakdown of that control structure actually benefits a class of musicians, of which I consider myself and most of my clients. The many thousands of records that I've worked on, the great vast majority of them are independent bands who don't participate in the mainstream music business on a corporate level.
Can I ask you a question, Steve?
Sure.
When you get to be 59 years old like me, and you choose to stay home instead of touring with your band in Eastern Europe, do you feel that you will still have the right to make a living for the work that you've done through your career? I have, at this point, had 230 cuts, approximately, by artists from Heart, Cheap Trick, Beach Boys, through Toby Keith, Laurie Morgan, Tim McGraw. I think I have a right to support my family and to build my own, continue to make a living in the music business, even though I choose not to tour Eastern Europe.
I think that's perfectly reasonable, but I think that your client base are those musicians who are buying and performing your songs. Those are the people with whom you have a business relationship. The rest of the world is not your business relationship. The people who are watching YouTube for their own personal entertainment are not your.
But I ask you a question: do you think at that point in time in your career, if you make the same choice that I've made at my age, do you feel as though you would would have a right to continue to make a living from the work that you've done to that point?
Frankly, no. I expect to continue working in order to get paid, the same as anyone else who has a job.
You might change your perspective when you get to this point.
Sir, I'm 47 years old. I'm not that far away.
Another thing is about choice. So if Steve chooses to run his business model like that, that's fine. That's great. He chooses not to be a BMI, ASCAP, or CSAC member and have them handle. Well, are you a songwriter?
Well, yeah.
I mean, do you have copyrights in your song, in the musical works?
By the fact of having written them, yes, I do. But I haven't formally copyrighted
Well,
them.
that's right. I mean, you don't have to in order to have a copyright. but,
Exactly.
your band may be a situation where they're the songwriters and they're the performers. Not like Rand is a songwriter, and that's what he does. So, I mean, it's a different situation. And for him, a performing rights organization is important.
I
So
understand
if
what
you
you're
want to
saying.
do that,
I'm
that's
saying
fine, but you don't have to annihilate IP rights for everybody across the world.
By the enforcement of intellectual property rights across all platforms like this, you are enforcing that paradigm on people like me who choose not to participate in that business model. We would rather have a direct relationship with our fans. And let's say that somehow the decision is made that YouTube must pay for any usages like the Prince usage that we just saw. YouTube is not going to pay. What they're going to do is take those videos down. Prince will make no additional money from having insisted on being paid. What will happen is that people will not see the stuff that they want to see on YouTube. It's not going to create additional money. People have demonstrated that they're not willing to pay for things like that. So this money is not going to get squeezed out of a turnip. What's going to happen is that avenues of communication are going to be closed off for fear of having to pay.
Hey, can I just
Yeah.
address that? So the night before Google paid $1.65 billion for YouTube, I was in London. And for those of you copyright people out there, you'll know that the English don't have a fair use doctrine. They don't have any kind of private copy doctrine. And I was doing some interviews with Reuters and some other people about the YouTube deal, which was anticipated but had not been announced. And I thought, I'm going to go check out YouTube. I haven't seen it in a while. Just make sure I know what I'm talking about. So I started searching for things. I ended up spending about an hour and a half on there. They had 19,000 instances of the Beatles. They had, a whole bunch of mainstream stuff, old catalog stuff, all these things. And I thought to myself, boy, we sure have created, as an industry, we sure have created a lot of really great stuff. I wonder what it's worth. And the next day I found out. Zero. It's worth zero, right, to Google. It's worth YouTube, whatever YouTube is without all that stuff, is worth $1.65 billion to somebody. But our stuff is worth zero because we didn't get paid, right? So the thing about YouTube is that what they'll do, and I would disagree with you, Steve. I understand what you're saying, and I essentially agree largely with what you're saying in terms of the spirit of it, in terms of having an alternative distribution channel for independent musicians, and I think that's really important. And if they were doing it for charity, I'd be a lot more sympathetic with them, but they're not. They're doing it for $1.65 billion, which this is what you call the hybrid economy, right? The hybrid economy is where they capture the value up here and they don't share it down here, right? Now, they have gotten licenses. They have paid out some money, but really it's chump change compared to what they received for the company. I would be shocked if YouTube has paid out over $200 million in advances to all copyright owners who they have licenses with, right? Which is one of the reasons why Warner hasn't re-upped. And that's what you're going to see. You're going to see when Warner, people who had deals who don't re-up will just not have their videos shown there, right? Then there's then what they will have is they'll have a nice little block that says, because some lawyer didn't have the brains to negotiate this out in their deal, they have a little block that says, neener, 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 you can't see this video because Warner won't make a deal with us, right? That's what you'll see. So, I agree with you in the sense that I think it's important for independent musicians to have the choice to have their videos up there if they want. I think that it's important for independent musicians to be able to distribute their videos or their records over P2P networks, which is their choice. And I represented the original Napster, and I represented Sean's second company, Snowcap. So, I have firsthand knowledge of all this stuff, and I completely agree with that. But at the same time, I also respect the rights of other copyright owners to not participate, and preferably not to have the neener, neener, neener ads up there if they choose not to participate.
Christine, something that you had mentioned regarding control and the copyright owner remaining in control of how their work is used. Kind of would like to move on to the question of if some of that control were relaxed, and this can either be legislatively or through some court decisions, or just in a shift that I think we've already started to see, going back to Chris's collectivist question. But much of it is quite unresolved. If I can just play an example, and if we can talk about a particular use. Let's see. What I'm getting at is the unauthorized use of a considerable amount of work in an audio mashup. Okay, could be video mashup as well. So the context is, are we creating new work here? And should this be allowed under our fair use discussion? So here's an example where an album was released this summer with 322 unauthorized samples, some very, very short, less than a second, and others as long as 40 seconds. I would like your comments on this. Let's just have a listen. And here's a list, not a complete list, by the way, of the samples used in this mashup. Okay, one of the things we take a look at when we're analyzing fair use is how much was used. And again, in this case, we have some very short samples, but obviously some very identifiable, lengthy samples. Quick story on that. Earth, Wind, and Fire, September, written in 1978. Al McKay was one of the co-writers on that, and I used to write with Al in Los Angeles, and I happened to call him up when this first came out. This is Girl Talk, Feed the Animals, came out this summer. And I asked Al, are you hip to this Girl Talk record? And he had no idea what I was talking about. So I held the phone up to the speaker and played this, because it's about 40 seconds of September. And Al said, I'm going to call you back. I've got to call my attorney. So the question, though, maybe the bigger question, is this creative use of existing material? We can argue that all day long. This creates new work. I mean, should we support this? Or should we say he's really not, he has to get permission to use every single sample? And again, in this case, as Christine was pointing out, there are 2 copyrights in each sample used. The underlying work, it's the song, and the recording of that song. In a couple of cases, I think the Beach Boys and there's a James Gang, Funk 49, was pre-1972, so there was not a federal copyright protection for the sound recording. But there are only a couple in the whole album of 322 samples that would fall into that category. So
That doesn't mean there's no copyright protection, by the way.
right, but
Right.
federal copyright
Federal.
protection
There's
for the
state
sound
law
recording.
copyright.
Okay. So, Patrick, I'd like to throw this out with you. Again, in the spirit of copyright is put forth in our Constitution, that it gives us the incentive to create more stuff, given certain protections to the creators. But should this fall into the fair use category, look the other way? He is selling a lot of albums, and he's certainly getting a lot of people to his shows. But should Earth, Wind, and Fire and the other 321 songs get a license fee for this?
I'm not going to answer you directly, Todd, because I don't have the legal know-how to do it. But what I will say is that cyber libertarians are, and anybody involved with post-punk music making and sharing in that kind of collective ethos really believes in prioritizing non-economic values over economic values. You know, it's so important to have access and participation not only for artists, but also for fans, and interactions between artists and fans that give and take are part of what constitute a music community. And I think from a cyber libertarian point of view, it's just really important to say, you know, let's not put ourselves in a box and create new forms of illegal art, okay, through copyright law. And that's my main concern. And so I'll leave the details to the lawyers to figure out. But I think that in principle, the idea of illegal art is very troublesome, particularly for an open society such as ours.